We want to share with you an interview that Tony had with Louisiana Solicitor General Ben Aguiñaga on the weekend program This Week on Capitol Hill. And they talked about a case that ties into the discussion I just had with David Cortman of ADF. And it highlights how anti-religious groups don't really understand the Establishment Clause, and so they try to remove anything related to faith from the public square, which is certainly not what our founders intended. But we'd like to take that and let you enter into this conversation that Tony had. And here's how he got that conversation started.
So you were before the Fifth Circuit. I was there in the courtroom listening to the arguments. I thought you did a tremendous job laying out the case for this. What was at the core of the opposition to these 10 commandments being placed in public school classrooms?
Sure. Well, I think the lead argument that we heard from the other side was that simply posting the 10 commandments, and we can talk about, the various ways in which that could happen, but simply posting the 10 commandments on public school classroom walls would be coercive, unconstitutionally coercive to students. I think the theme is that somehow that would, force students to change their religion, force those who have no religion to adopt religion. And I think what we heard from the argument was the judges struggling with that theory, because that's not any theory of coercion that the Supreme Court has ever endorsed. There are plenty of school cases from the Supreme Court that talk about coercion to participate in a religious exercise, but there's no plausible argument that simply posting a passive display of the commandments on the wall somehow coerces somebody to participate in a religious exercise. And so I think you heard a lot of struggling about that, but that was the main argument we heard from the other side.
I found it interesting that was everything, their opposition is built on that one challenge that this is coercion, and that happened to be the subject of an amicus brief that the Family Research Council filed in that case, explaining that coercion requires you to engage in some type of religious exercise with either punitive action taken against you if you don't do it, but this is a passive display, and it at the end of the day, based upon the full court's questioning, it appears that they really zeroed in on the opponent's challenge here, and it looked like it was Swiss cheese by the time they ended up.
Right, and I think that's understandable because anybody who's followed Supreme Court precedents in this space over the past couple of years knows that the Supreme Court has told lower courts you've got to look at history and tradition to understand what the Establishment Clause actually prohibits. And what it prohibits is what was familiar to the founders, which was true establishments of churches. So, for example, a government that coerces somebody to attend a church, punishes those who refuse to attend a church, expressly funding a church. These are things that our framers and the founding generation were well familiar with. And that, that's the analysis that drives the cases today, which is to say, whatever's challenged in this case, does it look like an establishment of a church that the framers were concerned with? And that, I think, is the biggest obstacle that the opposition in this case really ran into, is that they've got nothing as a historical matter that says simply posting a passive display of a religious symbol somehow amounts to establishing a church.
But your opposing counsel said that posting the 10 Commandments on a public school classroom wall turns it into a church. He said that there in the courtroom. That would mean that the U.S. Supreme Court and other places that have recognition of these documents and their importance to the founding of this nation, they too should be declared churches.
That's exactly right. And think about the House of Representatives chamber, which has over 20 depictions of historical lawgivers, Moses chief among them. Everyone in that chamber is oriented to look at Moses. That Speaker of the House, when he's on the dais, is oriented to look at Moses. As you say, our nation is covered with religious symbols and acknowledgments of the fundamental role that religion has played in our nation's history. The Supreme Court has said, obviously, that's a thing, and schools in our position, schools obviously have good rights to say that we want to teach our students about this foundational document in our national history.
General, we just have about 30 seconds left. Timing of a decision by the Fifth Circuit, and will this ultimately end up before the Supreme Court, in your opinion?
So we don't have a strict timeline. I think as a matter of practice, the Fifth Circuit typically tries to get opinions out within about 6 to 8 months after an oral argument. So potentially we could see a decision this summer, maybe early in the fall. And then I do think that whatever side loses in this case will probably appeal to the Supreme Court. And this is a very important case for not just for Louisiana and Texas, but for states across the country. And, at that time, we'll see if the Supreme Court's interested.
Ben, thanks so much for taking time to join us. And again, a great job today, this week before the court.
All right, that was Tony's conversation with Louisiana Solicitor General Ben Aguiñaga. That took place on Tony's weekend program this week on Capitol Hill. And by the way, if you'd like to catch more of that program, you can visit the website there, thisweekoncapitolhill.com. All one word, no spaces, thisweekoncapitolhill.com. Or better yet, you can just watch the entire program on our Stand Firm app, which if you don't have, just simply text the word app, APP, to 67742.